I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, I am bringing you number 103 on our compilation list, and we're going to be in 4 different judges' courtrooms. Before I give you the rundown on those judges, don't forget to like, comment, share, subscribe. You guys have been doing amazing. It's been really helping us with the algorithm. We see YouTube is really doing their job on these AI channels, so that's helping us get some of these views back. So guys, keep up the good work because it is really helping us out here on the channel. Now, you guys that follow the channel know there will be no commentary added to this compilation, and there will be chapters added for your convenience. Now, the 4 different judges' courtrooms we will be in on today. First, we will be in the courtroom of Judge Warren Davis out of the state of Georgia. Second, we will be in the courtroom of Judge Laura Echartea out of the state of Michigan. Third, we will be in the courtroom of Judge Shawn Perkins, also out of the state of Michigan. And last but not least, we will be in the courtroom of Judge Tim Lewis out of the state of Washington. Listen, guys, let's get ready to jump into number 103. I think it's about that time, so let's go.
All right, then we will go to Ms. Celestine's case. We will let the state be able to set up. There's very important issues today. Now we were on this, well, just set the case up a minute. It's back to me.
All right. 23B 1593 etched in.
Okay. All right. Ms. Celestine, actually, as I told her earlier today, I had various important legal issues to take up. She was disruptive. After repeated warnings, she was removed from the courtroom. The next important issue, and if Ms. Celestine would quit trying to represent herself, she would have seen this. There was a bench warrant issued for her arrest. She appeared in court on that bench warrant. Therefore, the bench warrant was resolved. Her prior examination by the record indicates that her prior bond had a judgment forfeiture, which was cured. The sheriff levied, it was satisfied, the bond was never set aside. So if she would have spent more time on paying attention to the legal principles that actually apply, other than this nonsense gibberish, she would have realized it. But she didn't. So now the state has filed a motion to revoke the bond.
Yeah.
And that's the important matter we're on today. So, and she's entitled to notice and due process. So that's why she was brought over today, because those matters are expedited. So let me hear from the state on the state's motion to revoke bond.
And Your Honor, some of the facts you've already put in the record. I will say that on June 21st, 2023 is when the defendant failed to appear in Ellen. The bench warrant was issued. Subsequently, October 20th, 2023, a bond forfeiture was granted. We would submit to the court that basically for 2 years, the defendant evaded the bench warrant. And it looks like September 16th, 2025, the defendant was arrested by Georgia State Patrol, and that was for new offenses of obstruction, distracted driving, suspended license, and improper use of intent. The state arrest meeting, that was September 16th, 2025.
Right? So after the time she failed to appear in the court, Did she have any other arrests other than this traffic theft?
Not that I'm aware of.
Okay.
And so it wasn't until this arrest by Georgia State Patrol that they discovered the benchmark was unstable. So we would submit to the court that based on the defendant's own statements in court and her filings, she does not recognize this court's authority. She does not believe this court has any personal jurisdiction over her. And we would submit that any bond condition she would just ignore. And she does pose a flight risk. Secondly, we would submit to the court that when she was arrested, she basically committed several offenses, which was out on bond, with the exception of the fleeing and attempting to elude and the possession of the marijuana. The remaining counts are virtually identical to the counts that she was arrested for: distracted driving, no license, no license plate, obstruction of police. And so we would argue that she violated the conditions of her bond, and she does pose a danger to the community.
Okay. Is she out on probation or parole on any prior offense?
I don't believe so. I don't believe so.
Okay. And when she was arrested, did she give a new address?
No, I believe she gave the same address as the arrest.
Which was what?
Everything. Yep. Thanks.
Yeah.
The address I'm showing is 2214 Upward Falls Avenue, Latham.
Falls?
Yes. POPLAR. And the zip code is 30058.
Okay. Now, Ms. Salastine, that is the issue before me is revoking or modifying your bond. I'll give you an opportunity to be heard in the courtroom if you will come in and get to the point of that. If you keep giving me those nonsense legal claims, and I've been hearing those for 40 years, man. They're nonsense. They're right up there with the Easter Bunny. I don't mean to insult the Easter Bunny. So you want to come out, I'm glad to hear for you. It's an important legal issue. But if you would have quit trying to represent yourself, you would have recognized that you could have posted bond, reposted bond. But you're more concerned with the nonsense than really what applies. And that is to your detriment. But you have a right to make bad decisions. Thus far, you've exercised them. All right, let's see if she wants to come out and be heard on the issue of revoking her bond. If she complies and she does what she's supposed to, I'm glad to hear her out. If she becomes once again disruptive, she will be removed.
Judge, she said that she would like to come out, so I will bring her to you in person.
Okay, so she said she won't come out of the holding cell. Well, that won't last very long.
No, she will. She wants to come out.
Okay, well, she'll come out. I mean, I'm glad to hear it's important.
Yes, sir.
So let's see whether or not she will comply this time.
Yeah. So it's in. Got it. Is it?
No, it's not. He's asking.
All right, Celestine is with us. Ma'am, the issue is revoking your bond. State is contending that your bond should be revoked. You don't agree with any authority to court, and you've been missing for 2 years. So, I'm glad to hear from you concerning what you want to tell me. Now, typically bond is based on whether you're a flight risk. So that's a big hurdle. Been gone. The second one is whether you're a threat or danger to the community. The third is whether or not you're a risk of committing future felony offenses. I've not heard that since you originally posted bond that she had any felony arrests. Is that correct?
Correct.
It's likely that you would pass that criteria. Right. I gotta make all 4. Now, the last one is whether or not you would intimidate witnesses or obstruct justice. I think all the witnesses in this case are wrong.
Yes.
So the likelihood of your intimidating them is just about 0. So the main issues for my reconsideration of your bond is number 1, you're a flight risk. Number 2, whether or not you're a threat or danger to any person in the community. I find that you qualify to the other 2 factors. So what would you like to tell me, if anything, concerning whether or not you should be, once again, you should leave your bond where it is right now, which I think was, what was it, 20-some thousand? 30,000. Or I should just strike it. So I'm ready to hear from you if you will get to the lawful point.
Right, I would like to make my statements without interruptions, because if I don't have the right to be heard, then we might as well just.
And you have a right to be heard on those issues, because that's the matter right now.
Okay.
If you don't want to talk about those issues, then that concludes this part of the hearing. The other part I've got that I still haven't been able to get through is your Ferretta hearing. They're not gift counsel. You've already missed a huge legal issue on the ability to post bond. And what a bench warrant does after you appear in court. So you're not doing well on your own.
Well,
Do you wish to respond to the bond criteria or not?
Well, first, the bond is excessive, and I'm not supposed to have to be compelled to pay any costs until a conviction on a felony on a final trial. So that is my 17th guaranteed protection under the Article 1, Section 1, paragraph 17 of the Constitution for Georgia. And Article 9 of the Constitution for the United States, which you have an oath to, states that y'all are not supposed to deny or disparage any of my inherent rights that are reserved to me. I have reserved all human rights, natural rights, consanguinity rights, birth rights, constitutional protected rights, and treaty protected rights. And they have been denied and disparaged as if they don't exist. Those are my retained rights. So I'm trying to understand, what are we doing? What am I supposed to do? What is my way out? What? I'm constantly feeling like you guys are usurping my rights. I don't even know who this man is, and he's bearing false witness against me. He's got a story that he has just finagled out of anywhere. I don't even know the people on this whole case. I don't know anybody, but I'm sitting here being again accused under and not presumed innocent. I'm sitting in chains in a inhumane living conditions. I've never experienced this. I don't have a record. This type of thing is for someone who is actually somebody who is a criminal. I'm not a criminal. I am innocent. And I keep trying to tell you guys my status and my rights.
I have given you your time for a little bit of your talking about the issues that don't apply to bond. Now we're back on.
I did give you Article
the two bond conditions, yes or no.
I gave you Article 1, Section 1, Paragraph 17. I'm not to be compelled to pay any bond, anything, until conviction on a final trial. And I should, Amendment 8, I should not be held under false imprisonment.
Okay.
Under cruel and unusual punishment, under any bail. That's the Constitution. And is that not correct, sir?
No, you aren't. It's something else you're wrong about. But anyway, ma'am, I'm once again saying
I can adjust this comments and be posted on the record.
this is where I'll have you removed, because right now.
You might as well. That's fine. I don't care
That's
anymore.
fine, but ma'am, you're clearly not going to respond to that based on the arguments before me and the non-response by the defendant. I find that the state has met their burden to revoke bond. So I guess in part you're having it granted. You won't have to pay anything because you're not going to have anything to pay.
That's fine.
So
Well, it's not for me, because I'm not, I'm here
bond is
with
revoked.
the
All right,
defendant,
take care, ma'am.
under be
We should
correct,
make different decisions.
arrest and coercion.
All right, take care.
What's your name, sir?
The principal name is Joseph Martinez Logan. I'm an agent on behalf of the principal.
I'm sorry, say it one more time.
I got a doable power of attorney filed in Wayne County Register of Deeds. Principal name is Joseph Martinez Logan. I'm an agent on behalf of the principal.
Okay, you're Joseph Montez Logan
Yeah,
or Logan?
Yeah, that's my principal. Yes, ma'am.
That's your name. Sir, I'm Magistrate Echartea. You're here on a criminal matter. 250-453-2601. You have an attorney. Go ahead, counsel. Counsel Reagan, you wait for a reading. Stand mute.
Judge, he's representing himself. He's the principal or the agent of the principal attorney of himself. He's representing himself.
Okay. So, Mr. Logan, you want to waive the formal reading, or do you want me to read the charges?
I would like to see the discovery first and the nature of the cause.
Okay, the discovery, that comes after, sir. Okay, this is only an arraignment. So my question is do you want me to read the charges to you or not?
Yes, ma'am. I'd like to hear the reading.
Okay, so, sir, people of the state of Michigan versus Joseph Montez Logan, allegedly on May 15, 2025, in the area of 18637 Albion Street, City of Detroit, did commit count 1, domestic violence, did make an assault or assault and battery upon a Tanisha Logan, a resident or former resident of his or her household, and or an individual with whom he has a child in common, and or his spouse, contrary to the MCL 750.812. Okay, maximum penalty is up to 93 days jail and or $500 fine. Do you understand that, sir?
No, ma'am. I do not understand that.
You do not?
At the moment,
what is it that you do not understand?
Well, because MCL 12.280 gives you the personal liability of my agent capacity, and that gives you understanding of 1 and 2, saying that I have the same rights as a self-appointed a state appointee, the same rights as a state appointee, and I have no interest in this matter.
Okay, well, sir, you are the individual. I'm going to enter a plea of not guilty. It alleges that you did make an assault and battery on a Tanisha Logan. Okay. Again, the penalty is up to 93 days jail and or $500 fine. I'm going to enter a plea of not guilty. Let me give you your court date, sir, which is going to be May 28, 2025, free trial. It's an in-person hearing. Let me make sure. 8:30 in person here at 36th District Court in front of Judge Austin Garrett. Do you understand that, sir?
No, ma'am. No, I do not.
No,
understand.
I don't think that, I think you do understand, sir, because by your talking, okay, you do understand English. Whether or not you disagree with it, sir, that's another matter, Mr. Logan. But
I'm here by
everything is placed on the record because everything is being recorded, sir. But I do believe you understand English. I'm giving you that court date. I'm also letting you know, sir, in terms of whether or not you wish to go forward, however it is, that's going to go in front of Judge Austin Garrett. Do you understand that?
No, ma'am. I do not understand any of the matter, any of the charges, none of what you're saying, because I'm actually the agent on behalf of the principal.
Okay.
No
Well,
personal in this case, and you try to build a case on me personally, and I'm not liable. I don't have an interest in this matter.
okay. Thank you, Mr. Logan, but you place that on the record. I've heard that. Sir, you still have that court date. I gave it to you. Okay. If you do not show up, a warrant will go out for your arrest. As to whether or not, like I said, when you want to argue as to motions or not, that's going to be between you and Judge Garrett. Okay. Let me give you some bond conditions, sir. That means you need to abide. You're not to have contact with a Tanisha Logan. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. You're not to possess any firearms or any other dangerous weapons, and you're not to go back to the no, that's your residence. So I'm not putting that on. Just no contact and no firearms. You understand that?
What happens with the minor children involved?
The minor children, that, let me see. As to the minor children, sir, okay, that's up to family court. So I'm not dealing with the minor children.
So there's no stipulations?
Those two conditions, okay? I don't see anything to indicate that these children are subject of this case. So do you understand what I've just said, everything so far?
Ma'am, I do not understand, but I will take your ruling on behalf of the principal. I can only do what I can.
Okay, no problem. Okay, this allegedly happened at your residence, sir. I also see in this particular matter, there was no injuries. The complaint declined medical attention. Let me see what else.
I got a question, ma'am. Is she moving forward with the case?
Hold on. Okay. There was a 2016 domestic violence misdemeanor. I don't have anything else. What's your question, sir?
Is Tanisha Logan moving forward with the case?
Is she a what?
She's pressing charges, Tanisha Logan.
Okay. So you understand, Mr. Logan, okay? It is not up to the complainant to press charges. Charges come from the county, the prosecutor's office.
Oh, okay. Well, I'm just of the understanding that the state of Michigan is a legal fiction. It's not a living person.
Okay. It's the state of Michigan. That's why I read the state of Michigan, or the people of the state of Michigan versus you, sir. So okay. It is up to the prosecutor's office that files the charges. They have filed the charges. Whatever happens after that, that's going to occur in front of Judge Austin Garrett, his courtroom. So I see that you have local ties. Anything else you want to add, sir?
No, not at the moment. No,
okay. Well, this is going to be it, sir. In this case, bond is going to be $25,000 personal bond. Nobody has to pay any money for you to get out of jail. I will caution you, sir, that you have no contact with the complainant. Even if the complainant wants to talk to you, you cannot, because you're under court order. Now, you can take all those issues up with Judge Austin Garrett on your court date of May 28th. Do you understand that, sir?
I was able to understand that this was a misdemeanor charge and not a criminal charge. So I don't understand how.
No, it is a criminal charge. Anytime when you can go to jail, you can be incarcerated, it is a criminal charge.
Yes, that's crazy. Okay, well, I'll just fight it in court.
So, $25,000 personal bond. Good luck, sir. You can step aside.
Judge, I lost Ms. Little. I don't know why she left the breakout room, but I'm in need of a client at the moment.
Okay. What about Lowe? Did the officers show up for Lowe?
Yeah, none of these work.
If the officers showed up, we can get Mr. Lowe. Oh no, Lowe was it's not an officer case. What happened to? Oh, he had to leave. He had to leave. Okay. Get you started on logins. Joseph Loggins. You there, sir?
Yes, I'm here, sir.
Good morning to you.
Good morning.
It's just log in. It's not logins, is it?
Yeah, no S.
City of Detroit versus Joseph Loggins. Case number SP 1322877, counts 1 and counts 2. SP 1688005, counts 1, 2, and 3. SP 1688081, counts 1, 2, and 3. Appearance for the record, please. Ms. Murphy.
Oh, none of these work.
Ms. Murphy.
You're muted, Ms. Murphy. You have to unmute, Ms. Murphy.
Could you hand me that file over there? Print it out already.
All right, what's going on?
Your Honor, as to Mr. Gildersleeve.
Hold on, give me a second. Give me a second. Ms. Murphy, can
Yes,
you
Judge.
put your record for logins, please?
Kathy Murphy, P51422 for defendant Loggins, who appears via Zoom, as do I, sir. Please state your name for the record, or ma'am.
Joseph.
Joseph, sir.
Sure.
All right. I'm gonna put you in a breakout room, Mr. Loggins, with Attorney Murphy. She's gonna get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial. Let us know what you want to do when you come out. Join the room, please. See anything here that's affecting him from getting a valid license if he doesn't already have one? It's past the matter. We need Loggins on an appointment. Let's go back on the record with Mr. Joseph Loggins. Mr. Loggins, I've given you an opportunity to speak to counsel. Counsel, your client wants an appointed attorney.
Yes, Judge, he would like to proceed to trial, and I'm asking the court to have an attorney appointed to assist him.
Here on this here this is sort of like, I mean, we can appoint one, but this is sort of like everyday stuff that we deal with every single day. It's only
Judge,
really documents. Go ahead.
So, pardon me for interrupting, Judge. Mr. Loggins has some sovereign citizen type claims to make in connection with these tickets.
Take your hat off. So if he got the sovereign citizens claims, then he doesn't want a lawyer anyway. Take your hat off, Mr. Loggins.
He did.
Go ahead.
He did say that he would like standby counsel. Mr. Loggins has some unique claims to make, Judge, that I cannot adequately represent for him at this moment.
And
but
I'm
they
sure
sounded like sovereign citizen claims to me.
And I'm sure probably no lawyer in the country can make that. I mean, he may be able to find himself a lawyer in the country that may try to make that claim. But Mr. Loggins, what do you want to do? I'm going to set a jury trial for this sovereign citizen stuff.
Well,
Is that what you're?
It's not sovereign citizen stuff, sir. It was due to the vehicle being registered to a living trust, at the time of the stop. So I was just informing the attorney that the claim is basically due to a trust being stopped. My vehicle was registered to a living trust.
Okay, thanks.
So the trust being the owner of the vehicle. So I just wanted to move forward as the trustee of the trust, if you will allow it.
Man, that's some double talk there, isn't it?
Judge, could I maybe jump into, I think I get what Mr. Logan's saying. If I could go into a breakout room with him for a second, I can talk to him. I'm still waiting for my client anyway, so I got some time.
All right, here we go. I told you there's a lawyer in the country that might want to represent you.
Thank you, Attorney Dupree.
All right, I'll put you in a breakout room. All right, let's pass the matter. Let's go back on the record with Logan. Logan, you want a trial date, right?
Yes, trial by jury.
Yeah, I think this would be best in trial by jury. Let the jury of his peers determine if they feel. Can I get a jury trial date, please? Are you going to be sitting with him on this, Mr. Dupree?
Judge, he is. He does want to represent himself, but he is asking for standby counsel. I'd be happy to serve in that role. I am on the Third Circuit standby counsel list, if the court would be willing to assign me.
I'll assign.
Thank you, Judge.
You do jury trial on certain days.
They have a list. They have a list.
Third Circuit does, Judge. At 36, it's all the same list. There's just one list.
No, you're saying, no, I'm saying the list for the jury trials. Let's see if I can find the dates on the list of jury trials. It is a list. Let's see here. We're going to set up 2 dates. Jury trial. Let's see here. And I got the dates. You can just look at it and see which one is. 2 for me. See June the 10th. It's probably too soon. June 24th. See what we got on June 24th. Or should we just go ahead? Because we've kind of July 8th. What about July 8th?
I was actually going to say, Judge, I have June the 24th. I'm currently booked for a jury trial in front of you. If the court doesn't mind double booking it, and I will, of course, note that Third Circuit frequently double books trials, I wouldn't mind double booking that either, and we can see which one, if either act ends out going.
Jury trial, June 24th. Okay.
Very good, Judge.
And then what's the final pretrial on that other case?
I knew you were going to ask that question, but still couldn't find the information fast enough. Give me 1 second, Judge. Judge, the final pretrial is the June the 23rd. You said it the day before.
June 23rd. June 23rd. Your next court date is June 23rd. Let Miss Snyder know that we want all the parties to appear on June 23rd. And not necessarily in person, but we want to make sure that they're gonna bring all the parties, so we don't order a jury if not. And that's going to be the same for your other June 23rd case as well.
I will let her know on both cases. And with Mr. Logan's permission, I'm also going to reach out to Ms. Snyder to request discovery in this matter.
Mr. Logan, do you give him permission to get the discovery for this matter?
Yes.
All right. Final pretrial, June 23rd, 2025. You know that the trial date is going to be in person. It's not going to be on Zoom. But the day before that, the June 23rd date can be on Zoom, 8:30. If you have any motions, I don't know if you're going to have any motions or not.
Yes, I'm gonna have some motions, sir.
Okay, so a motion date, you're going to have to get those in pretty quick.
That's what I wanted to see if you can extend the time so we can get discovery and look at it and analyze it.
I don't know how much analyzing you're going to need on it. Driving license suspended, no insurance, and an unregistered untitled. I don't know what what's really, it's not that in depth. I'm gonna give you, Mr. Dupree, he's probably gonna reach out to them today on that. I'm gonna give you until June the 13th on a response on the motion. Motions due June 13th, and the responses will be due June the 20th. Okay? If there's nothing further, Mr. Logan, I wish you the best of luck. Have a very good rest of your day, okay?
Okay, sir, can you repeat that again? You say the motions are due June 13th, and the responses are due
June 13th, and the response is going to be due June 20th, and I'll make a decision on the motions on the final pretrial date.
Okay, thank you.
All right, best of luck to you, sir. Have a very good rest of your day.
You too. Bye.
And sir, in the Nisqually jail, what is your name, please?
Raymond Charles Lafferty, Lafferty. How are you this morning, and how's the court?
Thank you, sir. And your date of birth is July 2nd, 1969?
That is correct.
Your Honor, before we go any further, I hate to interrupt. I am just going to need a couple of minutes in a breakout room with Mr. Lafferty.
Oh, sure. Okay, so Mr. Lafferty, there on the screen in front of you, you should receive a invitation to join a breakout room. Please click join. If there's no mouse in there for the computer, you'll have to ask the officer to assist you. But we're going to put you in a breakout room so that you can speak privately with your attorney before proceeding with your hearing, okay?
All righty then.
And you may need, if you don't see it on the screen, you may have to ask the officer to assist you.
It's not, like it says Lakewood Community Court inviting you to join room. Join.
Join, yeah.
Nothing on my end.
Okay, you can go ahead and ask the officer to assist you. The officer can help you get into the breakout room.
You mean your assistant?
All right, so Mr. Lafferty, just hang tight, and then I'll call your case as soon as the court is ready, okay?
All righty.
And your last name was what's it?
Lafferty, Laff.
Okay, I got you. Thank you, sir.
Mr. Reardon, did you have an opportunity to speak with Mr. Lafferty in private?
I did, Your Honor, and we are prepared to go forward with the arraignment. Thank you.
Thank you. Sir, you are before the court for arraignment. One charge of criminal trespass in the second degree is charged by the city of Lakewood and via criminal complaint 25L004378. Mr. Reardon, how would you like to proceed with the arraignment?
Thank you, Your Honor. I did have a chance to talk to Mr. Lafferty about this charge and his rights at arraignment. I want to enter a plea of not guilty on his behalf. Also, I do believe he qualifies for the public defender, Your Honor. I'm asking for direct appointment to the public defender's office without a promissory note. Thank you, Your Honor.
Thank you. Mr. Lafferty, the court is going to find that there is probable cause to support the filing of the charge. We'll enter
I find that there isn't. I may or may not be an arbiter of the law, having attended UC Davis and completed but not received my certificate. And the way that officer proceeded with me was not respectful or within the 24-hour period that had been stated.
Mr. Lafferty,
individuals in the park who took the pictures to make sure that it was unclear. Again, I had been made homeless by two officers from my nephew's house.
Mr. Lafferty, I would encourage you not to say anything just for now. The prosecutor is going to talk in just a moment, and then I will talk to you about.
As an indigenous person from California, I'm not sure you have any jurisdiction over me, and I wish that my tribal chairman, Curtis Lachusa from Mesa Grande, was informed that we have our own law and we have our own lawyers.
Mr. Lafferty, like I talked about, we can talk about your case, but let's go forward with this for now, and any questions you have going forward, we can talk about it after your hearing, okay?
Court is going to enter a plea of not guilty for Mr. Lafferty at this time and is going to waive formal reading of the criminal complaint. Mr. Taninga, what is the prosecution's position concerning pretrial conditions of release?
The city has no objection to the defendant's release on personal recognizance under the conditions the defendant have no contact with Kiwanis Park. And the defendant have no criminal law violations during the pendency of this case.
So then you're going to remand me over to being homeless in the state of Washington.
No objection to release on personal recognizance, Your Honor. I believe that's appropriate. Thank you.
Thank you. Court is going to follow the agreed recommendation of the attorneys. The court will release Mr. Lafferty on his personal recognizance. So Mr. Lafferty should be released later on this afternoon.
To be homeless as an indigenous senior citizen.
Court is going to impose a number of pretrial conditions.
I do not recognize those. Then I guess I won't be leaving jail.
Mr. Lafferty, please just hang tight.
Mr. Lafferty needs to appear in person and on time for all scheduled court hearings. His next hearing in this matter will be on August 12th, 2025 at 1 p.m. here at the Lakewood Municipal Court. The court is going to appoint Mr. Reardon to represent Mr. Lafferty.
I do not want Mr. Reardon. I want a tribal representative in charge of me.
Well, and Mr. Lafferty, if you choose to hire a different attorney, that is your prerogative.
That would be up to my tribal chairman and our legal defense team.
But at this point, the court is going to appoint Mr. Reardon.
I do not accept the appointment then.
And the court is also going to order that Mr. Lafferty have no criminal law violations, that he update the court of any change in his mailing address, that he have no contact with the Kiwanis Park in the city of Lakewood while this matter is pending. And the court has signed that order.
To be homeless. I'll just stay in
Mr.
jail.
Lafferty should be released later on today.
I refuse to be
Lafferty,
released.
thank you. That will conclude your hearing. You can let the officer know that your hearing is done. Thank you.
Incompetent fool.
And good morning in the Nisqually Jail. What is your name, please?
Raymond Charles Lafferty.
Thank you, sir. Mr. Lafferty is before the court in two different cases. 25L004378 for a second pretrial conference, 25L004397 for a first pretrial conference. Ms. Ganem, how would you like to proceed with Mr. Lafferty's pretrial conferences at this time?
Your Honor, Mr. Lafferty would like to set this matter, or both matters, for trial today. We have selected the next, I believe, confirmation date. Additionally, he expressed to me that he would like to try to have somebody contacted through the tribes. He does have contacts in California that can arrange for possible tribal representation here in Washington. I've offered to assist him as best I can, but he's expressed that he feels most comfortable having somebody from a tribe represent him. And he has been speaking to that. So in the meantime, he does wish to get this on track for trial to proceed these cases. But there may be an attorney change if he can get that done. He's given me some limited information. I would ask the court to consider releasing him so that he can use his resources to address that issue. If not, he's given me some information that I can go on and I can try to get that ball rolling for him.
All right, so two separate issues that I think are before the court. Number one is setting the matter for the August trial term. Mr. Graham, any objection to setting this matter for trial the week of August 18th, 2025?
No objection for the August trial set, Your Honor.
All right. And
As
the court is
to the
reviewing.
form, my only concern is making sure we have the right readiness date, dependent on how the court rules on his release.
I'm sorry, Mr. Graham, you trailed off there. What was the last thing you said?
The form lists the out of custody readiness date as opposed to the in custody readiness date. So I just call that to the court's attention in case it needs to be adjusted.
Quite right. And that leads me to the second issue. Let me finish going through the pretrial conference form first. Okay, the court has reviewed the pretrial conference form. It does appear to be appropriate. Now, Mr. Graham, I understand Ms. Gannon would be making a motion for modification of conditions of release. I believe bail was previously set in each of these two cases. My understanding is Ms. Gannon is asking the court to reconsider that decision and to release Mr. Lafferty on his personal recognizance in these matters.
Yes, Your Honor, and the city objects to that changing conditions. The reasoning for holding Mr. Lafferty in the first place is that we have two matters that are before the court, both involve criminal trespass, the second of which both involving the same location, I believe the Kiwanis Park. The reason to hold Mr. Lafferty is that he was told not only by officers but ordered by this court to not return to that park, and yet did so anyway, or at least there are probable cause to believe he did so. So based on that, Your Honor, I don't believe there should be a change in conditions at this time based on his prior behavior in following the orders of the court.
Thank you. Ms. Gannon, your response?
And Your Honor, I mean, I understand the city's position as well as the court's position when they set bail in this matter. Just looking at his background and the nature of this charge itself, I would ask the court to reconsider, especially since this matter is currently set for trial. And he has expressed his concern about his representation, and he does want to reach out. I did explain the possibility that bail would remain, and we'd have to be preparing for this trial while he's in custody. He understands that risk and is willing to go forward and ask the court to set this matter for confirmation and trial and to reconsider bail at this time.
All right. So yeah, I think the recitation from Mr. Graham is accurate. I think the recitation from Ms. Gannon is accurate as well. The concern that the court had was the alleged incident date in case number 4378 is July 16th, 2025. And I'm just taking a look here at the docket to make sure that my dates are correct. Mr. Lafferty appeared before the court in that matter on July 17th for arraignment, and the court released him on his personal recognizance at that time on a number of conditions. One of the conditions being that he not return to go upon the property, ever have any contact with the Kiwanis Park in the city of Lakewood. And then the very next day, he was arrested at the Kiwanis Park and charged again with a additional count of criminal trespass in the second degree. And so at that point, the court was very concerned that he was violating the court's pretrial conditions of release to have no contact with that park, and also, frankly, violating the court's pretrial release condition that he have law-abiding behavior. So, Ms. Gannon, I guess I'm going to kind of turn back to you. Have you had conversations with Mr. Lafferty that lead you to believe that there has been a change in circumstance, that now he better understands exactly what the court is ordering him to do and not do?
Your Honor, I did not have that conversation with him, so I have no opinion on any change besides the fact that he is looking for different counsel.
Okay. Do you want an opportunity to speak with Mr. Lafferty in a breakout room? Because frankly, before the court is going to release him, the court would need some assurance from Mr. Lafferty through you that he is going to comply with the court's pretrial conditions of release. Right now, I see him shaking his head no. So the answer may be that no, he does not intend to comply with the court's pretrial conditions of release. How do you want to handle this, Ms. Gannon? Do you want to speak with him privately?
Yes, very briefly, just to explain a little bit about the court's concerns.
Sure. So, Mr. Lafferty, you're going to be invited to join a breakout room there on the screen. If you could please join that breakout room, that will allow you to speak with Ms. Gannon privately. If you need any assistance getting into that breakout room, you can ask the officer for help.
Officer, I need help.
Ms. Ganem, do you have any additional information that you would like to share with the court regarding Mr. Lafferty's willingness to abide by the court's pretrial conditions of release?
I do not, Your Honor. He wishes to have bail remain.
All right. Well, and the court does want to note for the record that when I was having that conversation with Ms. Ganem before we went into the breakout room, when I was asking Ms. Ganem about the possibility of Mr. Lafferty indicating a willingness to abide by the court's pretrial conditions of release, I did observe that he was shaking his head in shaking his head no, which leads the court to believe that he does not intend to comply with the court's pretrial conditions. So pursuant to CRLJ 3.2, the court does have a concern that Mr. Lafferty, based on his own assertions, will not comply with the court's pretrial conditions of release. And so the court is going to leave bail as set in this matter at this time. However, the court is going to go ahead and set the matter for trial as requested by the defense. Mr. Graham is absolutely right. The readiness hearing, let me check with the court clerk. When would you like that set, Wendy? Because on the Nisqually calendar on the 14th or on the 13th? Okay, so we're going to go ahead and set that readiness for the Nisqually calendar on August 13th, 11 a.m. Other dates will remain, and the court is going to go ahead and sign that order. We will see Mr. Lafferty back here for readiness hearing on August 13th at 11 a.m. from the Nisqually jail. Mr. Lafferty, that will conclude your hearing. Thank you very much. You can go ahead and let the officer know that you're done.
I'm not threatening you. Say one more word and that's 30 days. 30 days.